Hello everyone, and welcome back to The Lawyer Talk, a podcast by BLawyers Vietnam. I am Huynh Kim Thanh, and I am delighted to be your host for today's episode. In this day and age, personal data is often compared to a raw resource for businesses. However, to exploit this resource legally and effectively, there is one crucial element that business cannot overlook. It is customer consent. Therefore, our topic today is 3 key considerations regarding data subject consent that businesses must grasp to build a standard and compliant data governance process. First consideration, which data require consent and which do not? A question I believe many of us ask ourselves is, does every bit of data we want to process require prior permission? And the answer is nearly all of them do. But there are a few exceptions. According to Article 9 of the Laws on Personal Data Protection 2025, the general principle is that when a business performs any action from collection and storage to usage, whether it's basic data like names and phone numbers or sensitive data like health status, the businesses must obtain the data subject consent. However, this law also provides 5 exceptions under Clause 1, Article 19, which I consider as urgent situations, including: first is urgent cases. For instance, to protect the life, health, or honor of the customer themselves or others in an emergency. In such cases, the consent requirement is waived to ensure the timeliness. However, the party involved in controlling or processing the data bears the burden of proof for these circumstances. Second is matter related to emergency situation, threats to national security. Third is for serving the activity of state. Fourth, a very important point for businesses is the contractual fulfillment. When a data subject has specific agreements with relevant agencies or organizations as prescribed by law, the consent is not required. And lastly, the other cases prescribed by other specialized laws or decrees. However, we need to take note that no consent required does not mean businesses are exempt to data protection responsibilities. Under Clause 2, Article 19, businesses are still mandated to establish a strict internal monitoring mechanism for the exceptional cases. Second consideration, this is the validity of consent. Moving to the second point, we must realize that only obtaining consent is not enough. We must also ensure the validity of that consent. This is governed by Clause 2, Article 9 of the Law on Personal Data Protection 2025. Accordingly, consent is only valid if it met 2 factors. First, it must be voluntary. And second, the consenter must be fully informed about the types of data processed and the purposes, the identities of the data controller and processor, and their respective rights and obligations. Furthermore, Clause 3 and 4 of this article specify that, firstly, the method of consent, it must be expressed clearly and specifically in a format that can be printed or copied in writing, including electronic or verifiable format. This is also further guided by Decree number 356 of the government, effectively on 1st January 2026. Secondly, the 4 core principles under law on personal data protection, including: first, consent must be expressed for each specific purposes. Secondly, it must not be together with mandatory conditions that require consent for purposes other than the agreed upon content. Thirdly, consent remains valid until the data subject change it or as otherwise required by the law. Lastly, silence or lack of response shall not be construed as consent. So, how should businesses implement this in practice? Depending on the scale and sector, each company will have a different design. However, BLawyers Vietnam suggests the following 4 practical solutions. First, build a simple tool with user-friendly interface that helps users easily understand the importance of data protection, rather than just displaying the try notification box. Second, write consent requests that are concise, succinct, and easy to understand. Avoid overly complex legal terms that may confuse the reader. Third, categorize the purposes of data use and utilize a checkbox method, allowing customers to proactively choose what they wish to share or agree to. Fourth, establishing a storage system to log consented consent. For items the customer had not yet agreed to, you can record this and send follow-up requests via email or SMS later. So we can see that designing a consent process that is both professional and legally compliant is a powerful way to affirm a business reputation and its respect for customer privacy. Third consideration, the right to withdraw the consent. We have discussed how to obtain consent and its validity. However, there is a practical aspect that businesses must handle in care. This is when the customer wishes to withdraw their consent. According to Article 10 of the Law on Personal Data Protection 2025, data subjects have the right to withdraw their consent or request restricted processing if they have doubts about the scope, purpose, or accuracy of the information, excluding the exception I mentioned in the first consideration. And this is a significant power because without a clear response process, businesses face substantial legal risks and management complexities. Therefore, we would like to share the following 3 points. First, regarding the form of the request, the law stipulates that a request to withdraw consent or restrict processing must be made in writing, including electronic or verifiable formats. To avoid inconsistent request format that lead to management difficulties, I advise businesses to establish a clear process and agreement with customer from the outset. For example, design a withdraw consent feature directly on your website or publish a corresponding standard form. This ensures convenience for customer while helping the business manage the record scientifically. Secondly, paying attention to the time frame for receiving and fulfilling requests. Upon receiving a request, the personal data controller or the personal data control cum processor is responsible for accepting it and must require any data processor to comply with the statutory time limit. Currently, the time frame is specially regulated in Decree 356, and we have a small tip for businesses if the data processor is the third-party partner, you should strictly pay them to response time clause within the service contract to avoid risk and could lead to dispute. Final point, businesses can rest assured that a request to withdraw consent is not retroactive. This means that all data processing activity performed prior to the receipt of the request still remain entirely legal. From this, it is evident that merely compliance with the written law is not enough. Preparing a system capable of anticipating potential risks is equally vital. Therefore, business need to calculate and review the system as well as the consent of contract with data processor and controller to maximize the protection of their interests. Due to the limited duration of today's podcast, we will conclude here. If you have any further questions regarding the above content, please leave a comment so we can discuss them in the upcoming episode. BLawyers Vietnam provide consultancy service for both domestic and foreign businesses and individuals in areas related to personal data, including legal advice, processing building, drafting terms and conditions, and working with state authorities. For more information about BLawyers Vietnam, please visit our website displayed at the bottom of the Lawyer Talk podcast screen. Goodbye and see you next time.